Hello and welcome. Today we're going to go through what goes into a parenting plan or custody agreement. Now we're here at part 3, where we're going to wrap up everything that is needed in a parenting plan to get it before the court and accepted. One thing that we haven't talked about yet are safety issues as to the child and perhaps even the parent. Now let's talk about the specific instance where there are safety issues as to a parent's behavior towards a child, the other parent, or perhaps even a third party. If you have safety issues, then those need to be addressed in a parenting plan as well. Oregon has specialized parenting plans designed specifically to deal when a child is or might be in danger from custody or visitation with a parent. Now, some examples of danger to a child or the other parent include a parent who has a history of violence, a parent who has been involved in abuse, be it sexual abuse of the child, the other parent, or perhaps a third party. If the parent has been involved in drug or alcohol abuse, him or herself. If the parent has been guilty of neglect of the child, and also other negative factors as to that parent, him or herself, the other parent of the child, or even a third party. If any of these factors are in play, then if the parent has visitation, the court might require that visitation be supervised. Supervised visitation is when the parent does not get to be alone with the child or children, but rather the parent has to have a third party there to observe and supervise the visitation to make sure that the children's well-being is always taken care of during a visitation. Now, generally, a parent who has supervised visitation or is subject to a specialized parenting plan that takes safety issues into account will not have overnight visitation. However, if a parent who is the subject of safety concerns has overnight visitation, that visitation will be designed by the court to protect the child. Now, obviously, there are a lot of different concerns that go into a specialized parenting plan when one parent is thought to be a danger either to the child or to the ex-spouse or other third parties that are involved in the custody and visitation of a child. So the court will make extremely detailed plans where there's no room for interpretation to prevent the parent who is the subject of the detailed plan from saying, oh, I didn't know, I thought I was supposed to be one place when I was actually someplace else, I thought something was allowed that is not allowed under the plan, and those sorts of things. So you can expect to have a very detailed, very restrictive, very set plan that gives the parent who might be a danger to the child as little leeway as the court feels is required in order to make sure that the child's safety and the safety of other people who are involved in the custody and visitation is taken into account and that those people are protected. So the question remains, who is it who prepares a parenting plan? Well, as you might suspect, it could be either the parent, especially if you are in court representing yourself, or as is generally known as pro se. A lawyer for a party will often draft a parenting plan to submit to the court on behalf of a party. Both parties can come to an agreement, which is called a stipulation, and present that stipulation to the court. Or if the parties cannot agree, or if a party requests, the court itself can draft and to a parenting plan for the parties. Remember, once you have a family law dispute that involves issue regarding the children and visitation and custody of the children, you will have a parenting plan. So someone is going to propose and submit a parenting plan, and the court must adopt a parenting plan before the case can come to a conclusion. There are real differences between parent-created and judge-created parenting plans in terms of what the statute requires be included in the parenting plan, as well as what factors can be considered for the court to approve a parenting plan. This is really important because you have so much more flexibility in parent-created agreements versus those that are created by the judge. First off, the parent-created agreements can take parents' interest into account. It can also be a basic or general parenting plan, which has a lot more flexibility in it than a detailed parenting plan for the parents to decide between themselves how they want to handle custody and visitation on a day-to-day basis. When the court steps in and makes a parenting plan, it is required under the Oregon statutes to make sure that it only considers two things when developing the parenting plan. A detailed parenting plan can be requested by a parent, or it can be the court's responsibility if the parents can't themselves come up with a parenting plan. So when you have a detailed parenting plan, the court only can take a look at what are the best interests of the child and take into account the safety of the parties. That means that the court is not going to consider what is convenient for either of the parents, what the parents' wishes may be, and even what the child's interest might be in terms of where the child wants to live or how the child wants to divide his or her time. The court only gets to decide what the parenting plan based on what the court determines is in the best interest of the child, and make sure that the safety of the parties is preserved as well. So those two things make it really different than a negotiated and agreed upon parenting plan that the two parents had input in drafting and putting before the court. The court agreement also will be a very detailed document that breaks down very specifically when each child or when each parent is to have custody with the child. So I hope that answers a lot of your questions about parenting plans and custody agreements in Oregon. As I've said before, make sure that you understand that this presentation talks about general issues and developments in the law. That doesn't mean that this shouldn't be construed as legal advice for your particular circumstance. So if you have an issue about child custody or parenting plans that you need answered regarding your specific issues or problems, make sure that you talk with a lawyer in your jurisdiction to get the advice you need on your particular fact pattern. If you would like more information, please look at our other videos on YouTube. They're under Divorce Matters. You can look at our resources and information on alturaslaw.net. Also, if you are in Central Oregon and have questions about your child custody or divorce case, feel free to give us a call. You can reach me at 541-304-3030.